Yeah, come on up to the podium.
We can talk, man.
Hey, keep going.
Yeah, please.
Two case files, 24-02561 and
93 days, right? Is that what you recommend?
Yeah.
That's what you recommend, but you were cool with it. You said no probation. And hey, Andrew. Hey, Andrew. No. Andrew. It's not everybody's in the same socioeconomic class as you are. It was 400 for the tether just to buy it, and it was 300 for a month just to get it.
The last thing I want to do is put you in jail because you're causing an upset to the court.
I agree. Personally, I agree with that. What up, man?
I need you to relax.
Otherwise, I'm cool.
You're here on a review. Yeah,
I'm
here is
review.
Mr. Finley. All right, Mr. Finley, you have to stop. You have to stop. It's a review to get you back on the right track.
Right, but here's another thing, and
Yeah.
and here's another thing, and when we need people to, and you gave me time, that would be like giving someone time for a parking violation. It don't make sense, Andrew, you smart, man.
That's not how this works. I'm gonna give you a chance to relax.
Right. Just stand here and let's do the review.
Mr. Young?
I'm still here, good. And you can read it, all the statutes you want. If it doesn't make sense, it doesn't make sense, Andrew.
Mr. Finley, I have to hold you in direct contempt for continuing to interrupt the court. You're sentenced to a day in jail.
Oh my God.
Yes, good morning, Your Honor. Elizabeth Smith, P63010, appearing on behalf of Midland.
Okay, and then I see the defendant and counter plaintiff. Please state your name for the record.
Rachel Langoni.
Your volume is a little low.
Okay. Is that any better?
That's better. Okay, so today was the date that was scheduled for a motion for summary disposition that was filed by Midland. Let's see. And let's see. They're asking for the court to strike, excuse me, the defendant's answer and dismiss the counterclaim. Saying that the counterclaim doesn't seek relief that the court could grant. I'll let you make your motion on the record, Ms. Smith.
Thank you, Your Honor. To address the counterclaim first, I'm sure the court has had opportunity to review the counterclaim. It's a two-line counterclaim saying that she is seeking dismissal of the claims against her and asking for an award of $3,744. It does not go into any detail about anything my client would have done wrong. So there's really no basis on which to grant any sort of relief as to the counterclaim. As for our motion for summary disposition, reviewing the defendant's pleadings filed, the crux of the matter is she doesn't believe that she owes anything to Midland because the original creditor was a different entity. So it was a Children's Place credit card held through Community Bank. The account was used. We attached about a year and a half worth of billing statements to our motion showing use, purchases and payments on the subject account. In December of 2021, the account was charged off and sold to Midland. Also, as part of our documents is a letter sent by Comenity to Miss.
Welcome back to the channel, everyone. Today's encounter takes us to the streets of Blackpool, and things are about to get tense. What starts as a simple stop for suspicious behavior quickly spirals into a full-blown detainment under the Misuse of Drugs Act. Our main figure? A man who insists he's just lost, while two officers see something much more. The question, was this a fair use of police discretion or an overreach powered by pure assumption? Throughout this video, we'll break down every move every justification, and every word exchanged to see who really stood on solid ground. The officers enforcing law, or the citizen standing up for his rights. Stay tuned, because by the end, we'll uncover how a misunderstanding on a quiet street turns into a textbook example of tension between reasonable suspicion and
Langoni explaining that the account with Comenity has been charged off. It was purchased by Midland Credit Management. Any further communications and or payments were to be made with Midland Credit Management. Ms. Langoni did in fact contact Midland and set up a payment plan. The payment plan was ultimately defaulted with only 1 or 2 payments having been applied to the account. So there's just really no issue left to resolve. Midland owns the account. The balance due and owing, there's no dispute as to that. There's no dispute that Ms. Langoni had the original card. The only issue is her belief that she doesn't have to pay Midland. And again, based on the proofs provided by Midland, and the fact that there was in fact a payment plan set up with Midland, I'll point to the fact that Midland does in fact own the account, is permitted to collect on same. And so we're asking that Your Honor please dismiss the counterclaim for the reasons previously stated, and then also grant summary disposition on Midland's claim, as there really is no underlying.
Right from the start, we see a classic misunderstanding morph into confrontation. The man's calm explanation, "I went the wrong way," should have ended the interaction. But watch how tone and perception take over logic. When officers interpret hesitation or privacy as avoidance, they're applying what's called behavioral suspicion, not based on hard evidence, but instinct. Now, instinct is valuable in policing, but it's also risky when it becomes the only justification for detainment. Yours, what do you think? Is avoiding police ever suspicious enough for a search? Or is that just exercising one's right to walk away?
Plaintiff counter defendant's motion. Review.
No, and I did try to contact legal aid and get some advice. The only thing that she told me that I could do was to ask you to amend my response. As far as what she sent, I still, when we were here the last time and I met with counsel in a separate room, I still maintain that I would like to see the contract. Whether that's, especially between myself and Comenity, to see that they were legally able to sell the debt. Because if I could go to trial, I would show that the chances that the Comenity was paid for the debt. And I want to be able to show that. It's very different, because if I were to go to court with Comenity, that would have to go through a federal court. It's very different than saying that
let me get some clarity here. You're not disputing that you had a Children's Place account, correct?
Correct.
You're disputing, and you're not disputing that there was a balance of $643.63?
No, I'm not disputing that.
Okay, your dispute is that you have paid that $643.63?
It was paid when I opened the account.
And there it is, Section 23 of the Misuse of Drugs Act. This clause gives police the power to detain and search individuals if they have reasonable grounds to suspect drug possession. But here's the issue. Reasonable grounds is subjective. One person's caution could be another's avoidance. What's fascinating here is that the officer builds his entire justification around body language and geography. Not a smell, not an item, not even a report. This moment marks the turning point. The man goes from free citizen to detained suspect, not because of evidence, but because of interpretation. That's a powerful.
Your Honor, if I may, I believe this is, we've seen this going around online. It basically comes down to an argument that credit cards aren't real money, and somehow by opening a credit card, Comenity is really doing some other sort of banking thing, and it's not really money that has to be paid back. You have
to let her give her response, because she's not actually drafted a motion or
Sure.
responsive motion to you. And then I'll let you respond. to what she's saying, but she's got to have an opportunity to make her statements as to what she believes her defense is.
Sure.
So you're saying you didn't pay, you charged $643.63 on the Children's Place card, but you didn't pay for it?
I did pay on it at the time because I didn't realize what had happened. And when this all started, when I started questioning what was going on, I had called
What do you
Commending
mean what was going on? I don't know what that means.
when I was trying to understand the legalities of a contract and how the banking system works. I was just studying this on my own. And so I had called Commendity a couple times, spoke to 2 different people, and all I did was I wanted the original contract so that I could learn the legal terms, how it works, the process. And when they kept telling me
Okay.
that they didn't have this contract, that's when I started asking more questions and learning that how important contract law is, and the fact that it's somehow magically disappeared. I don't understand why the most important legally binding contract would have just magically disappeared. So I started asking a lot of questions, and what I'm basing it off of is off of federal regulations, federal codes, the UCC 3. It's not what the attorney just made it out to be, but it is.
Notice how calm but firm the man remains. He asks intelligent, consistent questions. What's your call number? Where are you based? Showing he knows his rights. Yet the officer keeps circling back to demeanor, tone, and body language. This circular reasoning exposes one of the biggest gray zones in policing. Asterisk how much weight should attitude carry in establishing suspicion. Here's the kicker. The law allows police to act on reasonable belief, but that belief must be objective, based on facts any reasonable person would agree with. Here, the evidence feels more emotional than factual. If you were in his shoes, would you comply quietly or challenge the officer?
Just get to skip over that portion. If there is a motion for summary disposition, they're saying that you don't have a valid defense, that you have not presented an issue of genuine dispute. You need to now plead to me something that makes me believe that there is an issue of genuine fact that needs to be resolved by either a jury or a trier of fact. And you've not yet provided me that. That's why it was important for you to respond in writing to their motion. I'm giving you an opportunity now to respond verbally, but I need to hear some information that would allow me to understand your mindset and why you believe that you can open a credit card and then charge a balance and then not have to pay the balance.
Right, and that's
So answer that.
it is very difficult to explain, but I 100% would not have disputed this with Midland if that was the case, that I just wanted to borrow money and not pay it back. That's honestly,
Okay, so
that's not what it's about.
I don't mean to cut you off, but I'm trying to follow. So your dispute is that the past due debt was charged off. I'm not following what the dispute is.
I feel like I need to, I obviously I didn't go to law school, so understanding this process is not easy for me. And if I lose the case.
At this stage, both sides are entrenched. The officer's determined to defend his grounds. The man's determined to defend his dignity. What's interesting is that neither raises their voice. It's calm, controlled, but tense. The officer repeats the same rationale. You saw us and turned around. The man repeats, I simply went the wrong way. It's like watching 2 versions of reality overlap. One filtered through authority, the other through personal liberty. This standoff highlights how policing often hinges not on facts, but on perception management. Whoever controls the narrative, suspicion, or reason controls the outcome.
I would disagree with that because what you've said so far was that you opened a credit card, that you used that credit card to purchase some things, and then you didn't pay the credit card. And I'm trying to understand, but you said that the credit card, it was paid, and I'm trying to figure out how was it paid if you didn't pay it?
It's the banking process when I provide my social security number and did not fully understand what I was signing and what I was signing over.
Okay, so
it's-
because you signed a contract for a credit card and you didn't fully understand, you think that that's a defense?
Well, see, that's the tricky thing is my defense would be different with Comenity versus Midland. So
Oh,
anytime
we're not
that-
talking about that. We're not talking about what hypothetically your defense would be with Comenity. This is Midland Credit Management versus Rachel Lamco.
So I'm maintaining that they don't have there's no contract to base any of the allegations in the papers that Midland has submitted. It's
Okay,
it's
so-
all based off of if there was a contract, and there is no contract.
There's no contract, you mean, between you and Midland Credit Union? Is that what you're saying?
Or
credit
myself
management?
or myself in Comenity. Nobody has that contract.
No, I didn't ask you
either.
what, if anyone had the contract or anyone's produced it. I've already stated on the record that you signed a agreement with Comenity.
Right, but usually there's clauses in that agreement if they can legally sell my debt to a third party. So I would like to see that they could legally sell my debt to the third party.
Okay, so your defense was that you wanted to see evidence that they could legally sell the debt to Midland.
Yes.
And here's where things get personal, literally. The physical search begins. It's invasive by nature, but legal under Section 23 if the suspicion holds up. However, what we're seeing is a citizen uncomfortable not because he's guilty, but because he's being touched and treated as if he is. His request for a record copy is crucial. It's his only tangible form of accountability. This moment demonstrates why documentation matters so much in law enforcement. A single piece of paper, that search record, can later determine if this was a lawful stop or a rights violation. Transparency, or the lack of it, is often what defines justice in the
Dismissed, it's not properly pled, you've not provided any basis upon which the court can grant you $3,744 for responding to a lawsuit, which I'm gonna cut to the chase. It's very clear to me that you have opened up a credit card and you failed to pay the debt. Now, whether or not Comenity had the right to sell or transfer your debt to another entity, which is common in when you open up a credit card, that's unknown. Did you provide that information for her, Ms. Smith? We can't hear you. You might be muted.
Sorry, I did mute myself because I had to cough. I don't believe so, other than the letter sent by Comenity to her indicating that the account had been sold and Midland now owns it and was able to exercise full rights to collect on it. That was sent to her back in December, excuse me, of 2021. And that was included as part of the documents attached to our motion. And then again,
Okay.
I would also emphasize that there was a payment plan made with Midland as well, so.
She made a payment plan with Midland?
Yes, there were two $15 payments made, to the account.
When?
This was, give me a moment, Your Honor, it's in the motion. They were made, there was one payment for $15 made August 28th of 2022. That payment was actually returned on August 31st of 2022. And then there was another $15 payment was made October 27th of 22.
Why was the August 22 payment returned?
My system says declined. I'm not sure if, I mean, that could be like if a credit or debit card was used and then it ended up being, you know, like an invalid account number, or like the account got closed, or it could be an NSF.
Okay, but the October 27, 2022 payment was accepted?
That's correct, Your Honor.
Okay, so Ms. Langone, you've actually waived any defense or argument that you had that you didn't have a debt or a duty to pay.
This ending exchange shows something rare, mutual restraint. The man, though clearly upset, stays respectful. The officer, though firm, stays polite. It's not perfect policing, but it's not total abuse either. What stands out is how communication, even strained, prevents escalation. Imagine how differently this could have gone if voices were raised or cameras weren't rolling. In many real-world cases, the difference between routine stop and rights violation could be as small as tone and patience.